Now, since I have noticed,
It's okay, I'm just letting you know so when you call on me.
what's your name, sir?
Tomas.
Thomas? I'll call you Thomas. How's that? Okay, you're up, Mr. Thomas.
Prior to return to the job, prior plans to return to, now that our children, return to the job market after 20 years.
Okay, that was her plan. Keep going on until you see something.
For VK, just another day at the racetrack.
End of examination, have a nice summer. When you see a law professor write have a nice summer, you know you're just about to get turned to Okay. Now since we read the problem, you see how long that took? It took a long time. It took a long time for several reasons. Number one, it's the first time that we've done it together. This is the kind of analysis that you have to do at bar exams and also law school exams. They write these exams for a purpose. Every word usually means something. It's supposed to trigger off certain issues. It's supposed to trigger off certain inferences. And it's the same inferences, problem after problem. Now, if you want to be successful in law school, you're going to run back down to the library after we finish and grab every exam you can, especially from your professor. Because these are not original exams. These are variations of exams that they've been giving over the last 20, 30, 40 years. And it's really weird that if I do a lecture here at Brooklyn, 3 years from now I'll see the same exam out in St. John's. Because law professors aren't rocket scientists. And they talk to each other. And they give exams to each other. And they're basically, well, don't quote me, they're basically lazy. Okay? They're not rocket scientists. There's only about 9 issues in torts. There's the intentional torts, assault and battery, right? Then there's the negligence field, which is duty, breach of duty, damages, causation. Then there's the ultra-hazardous, strict liability, like if you have blasting or other kinds of activities. It's all the same, year after year, all right? Know about 9 issues. Know that they come up in problems. There's only so many ways a law school exam can be written. The issues are going to be always there. I'm sorry, in your discussion, you are to consider the potential legal significance of each incident. Assume that each party will make, I'm on the front page, assume each party will make all plausible tort claims against every other party. Okay. Who needs to use the bathroom? Good, then we'll just continue. Now, we've read the problem. Now we come to how to answer the problem. Take a sheet of paper out, blank sheet of paper. In every law school exam, you would take a blank sheet of paper and you would write AT. When you do the bar exam, you would take your blank sheet of paper and write a T. Half of your time in the exam is spent on analysis. Okay? Analysis. Who is the first plaintiff? Anybody. In this problem, who is the first plaintiff?
Ken.
Who?
Ken.
Ken. And who is Ken going to sue? Who?
May.
May. Does Ken have a cause of action against anybody else? So on the left-hand side, you put the plaintiff. On the right-hand side, you put the defendant. Ken has a cause of action against May in what? Okay, causes of action mean the theory of the case. In order to have a cause of action, you must have what? A prima facie case. What is a prima facie case? Barrington, I'm going to give you another chance. What's a prima facie?
You want a prima facie or a prima facie case?
What's your prima facie?
At first view or on its face, not requiring further support to establish existence.
What's that guy? What does prima facie case? Get your money back, please.
facie at first sight, on first appearance, but subject to further evidence or information. The agreement is prima facie valid.
Who's got a Valentine's dictionary? That's the one I use.
There's another.
Go ahead.
Sufficient to establish a fact or raise a presumption unless disproved or rebutted.
Anything else?
Prima facie case, number 1, the establishment of a legally required rebuttal presumption. Number 2, a party's production of enough evidence to allow the fact trier to infer the fact at issue and rule in the party's favor.
Boy, that's a lot of mumbo jumbo. That's how lawyers talk. Let me tell you how I explain a prima facie case to juries. Okay? Prima facie case. I cook. I'm a damn good cook. Every girlfriend I ever had said I'm the better cook, okay? But I also bake, and I bake cakes. And when you bake a cake, you have to have water, flour, sugar, a little leavening, and the exact amount. All right? When you cook, you can fudge. That's how all good cooks work. When you bake a cake, you can't fudge. It has to be exact. To make out a prima facie case, you have to have all of the ingredients in the cause of action. You can't fudge. If you don't make out a prima facie case, you're going to have motions to dismiss because you haven't made out a prima facie case, you have motion for summary judgment. You're going to get knocked out of the box if you cannot make out a prima facie case. So just remember the cooking analogy that I use. Okay, so Ken has a cause of action against May for what? Assault. What are the prima facie elements for assault? You have to know them. And on the exam, you say that Ken has a cause of action against May for assault. The assault is defined as, or the assault prima facie elements are, and you write them all down. Okay? So here's a cause of action for assault. What's a defense to assault? What am I going to say if I'm May's lawyer? How am I going to defend it? We're going to say that Ken cannot make out a prima facie case for assault because it's unreasonable for him to be put in fear. A reasonable person, based upon the actions, even if true, would not place a person in fear. That would be her defense. Okay? What other causes of action does Ken have against May? Did somebody say battery? What are the elements of battery? Okay? Yes, sir. You raised your hand.
Yeah. In
Thomas,
order to
right?
have battery,
Yes.
he has to have an injury.
Yes.
So it's actually an extension of assault in that with assault, there does not have to be a physical contact.
Okay. Does everybody agree with that? Don't all nod your heads at once. Does anybody disagree with it? Oh, everybody is agreeing with that.
I disagree with portions of it.
Go.
You don't need injury, the contact just has to be offensive.
You in the back.
Yeah, you just need contact and assault, you just need apprehension and contact.
Very good. Okay. Are there any other causes of action that Ken has against May? All right, before we go on to the next plaintiff, does May have any causes of actions against Ken? In civil law, we would call that a counterclaim. You, raising your hand, go ahead.
Actually, I was thinking, what about Ken's claim of libel or slander?
Oh, okay, I'm sorry, that's why I asked, are there any other causes of action? Libel and slander, okay? Now, what's the difference between the two? Yes, you in the mustard shirt, you raised your hand? Oh, you're scratching your forehead? Okay. You in the back, why?
One's in, I forget which one. One's in writing, one's verbal.
Right, which one do you think is in writing, which one do you think is in verbal?
I think libel's in writing.
That's correct, okay. And don't forget, there's also libel or slander per se, those four categories. They get tested all the time, all right? So one about the woman's chastity, business relations, you can look it up in the dictionary, but there's only four, and they're pretty well known. Okay. Any other causes of action Ken has? All right. After you do that, you check out the counterclaims that May might have against Ken. What you do here on your piece of paper, you list all of the causes of action. You list all the possible defenses on May's side. That's how you do your outline. That way, when you're in the throes of a bar exam, which is only in 3 years, in which you will be tested on about 35 different subjects, of which 12 you have never taken a law school course on, these are the techniques that you will use to successfully pass the bar the first time. So you don't get mixed up. It's a lot of pressure. It's 3 years away. You've got plenty of time to prepare. Who is the second plaintiff and who is the second defendant? Anybody. Come on, let's go.
Are we going to do the counterclaims?
What are the counterclaims?
Well, wrongful deprivation of property, like that.
Okay, so it's a property claim. I'll put fee for property. What else? This is against Ken.
Right.
Okay. You in the red.
What about $100?
Well, what about the $100?
Take it, it's May, so does the shopper pay for the money?
Okay. What money? You, Thomas.
Conversion.
Very good. Are you a first year or second year?
First year.
Did you do any summer reading? Be honest now. Okay.
I have studied law before that.
You have, okay. I thought if you're using the big words, you might. Barron, I'm going to give you another chance. Look up conversion.
So you're telling us not to buy a Barron's Legal Dictionary?
I think a reasonable inference, but I can sue for libel slander, is that there are some books which are better than others.
Conversion. Tortious deprivation of another's property without his authorization or justification. To constitute a conversion, there must be a wrongful taking or wrongful detention or an illegal assumption of ownership or an illegal use or misuse. Conversion is in the sense, a conversion in the sense of the law of Trover consists either of appropriation of a thing to the party's own use and beneficial enjoyment, or in destruction or in exercising dominion over it, exclusion or defiance of plaintiff's right, or in withholding possession from plaintiff on the claim of title inconsistent with his own.
Boy, that might be the worst, the price of admission. When you study law, you're going to realize that lawyers use a lot of words that you're unfamiliar with. But these are the type of words that you need to put down on the exam as buzzwords, because then you get credit for it. If you say it like a layperson, you're not going to get credit, either on the bar exam or the law school exam. And you got to use buzzwords that are familiar to lawyers. And the whole idea is that all of you in your course will use the same buzzwords, because psychologically, if the law professor keeps saying the same buzzwords over and over again, he's going to give you a higher grade. If you explain it in layman's terms, he's not going to even take the time to read it. And that's the reality of the situation. Okay, are there any other counterclaims that made against Ken? Yes, no, maybe. Going once, going twice. Moving on to the second plaintiff. Who's the second plaintiff and why? Who is the second plaintiff going to sue?
BK against name.
Very good. And what's the cause of action?
Assault.
As well as? Besides assault, what else? Is there anything else? No. Yes.
Battery.
Battery. What else? Is there anything else? Think about it. Okay. Yes, you in the back.
I have a question. The symbols are you using, are they official symbols or like just your own personal symbols?
I have terrible handwriting, man. I just use whatever I can. This actually looks more Chinese, but it's actually a B. Alpha is for assault. Beta or B is for battery. This is assault. Libel and slander. Property damage and money. They're not official. You know, you can make up anything you need to enjoy your memory. There's somebody else in the back row. Have your hand. You in the red.
Possibly indemnification.
Indemnification. Wow. Who knows what indemnification besides you in the red? Does everybody know what indemnification is? Darren will give it up on you. You. Wow. Please. Indemnification. So when you study law, you got to have a dictionary at your side. You got to memorize definitions because you're going to be using them.
compensation. The action of compensating for loss or damage sustained, the compensation so made.
Very good. Okay. Meaning that you're going to compensate somebody, you're going to repay them basically. Okay, are there any other causes of action VK has against May? Are there any defenses to the assault or battery? You do the defensive first, and then you do the counterclaim second. Does May have any counterclaims against VK? Okay, going once, going twice. You, in the back.
Al be a plaintiff as well?
I'm sorry, say again?
Would Al be a plaintiff as well?
Al, against who? And for what?
Well, he was injured.
Right, Al is injured, and whose fault is it?
And
How many different people can Al sue?
At least two.
Who said at least two? Who are the two?
Well, May or VK.
Right, as well as?
May and VK.
As
Oh, you're
well
saying
as-
there's a third?
I'm just trying to get him.
Right. I mean, it could be Ken, really.
Right. Why stop there?
Oh, yeah, I mean, it could be the...
When you're in
waste
litigation,
wheeling, it could be...
right, when you're in litigation, when you're doing civil litigation, and you're the plaintiff's attorney, what is your object?
Sue everybody.
Right! Why? You make more money. Plus, you don't want to have any defendant escape, because you know if you fail to include all of them, what are the rest of the defendants going to do? They're going to point the finger at the one that you didn't sue, and since the statute of limitation has just passed, you are going to be sued for malpractice. You want to protect yourself. So you use what we call the Scheifman approach, and you shake it out. You sue everybody. That's the practice of law. It has nothing to do with what you're studying in law school. Okay? It has nothing to do. All right, so how many other defendants does Al have?
Basically everybody else in this...
Right. Why would a law professor write an exam if you couldn't showcase your legal analysis? These are little things. Ken against May, VK against May. The meat of this problem is Al. Al. He's the big guy. Why? Because you could showcase your legal analysis. You could say, these are all the parties Al can sue. These are all the defenses or causes of action that he can sue under. These are the prima facie elements of each cause of action. These are all the defenses each of the defendants have to each cause of action. These are the counterclaims that they would have against Al. These are the cross-claims they would have against each other. Did I hear A+? Did I hear A+? If you showcase your talents on Al, you will get an A+. That's the whole purpose of this exam, so that you can put down as many causes of actions, that you can identify the prima facie cases, the elements of a prima facie case. You can identify the defenses to each one. You can think globally, cross-claims, counterclaims, results. And if you can do this and do it well, you show talent and you will get a to the J. A job! We're going to take a 5-minute break, and we're going to do another torts problem. Take your seats, please. Those who are leaving, you can leave quietly, please. Oh, it's a 73. I'm sorry. I called you 13. I apologize. All right. How should you be studying this semester? That's really important. If you only have 13, 14 weeks left before exam time, you have to be efficient. It's no good working hard. All of you Asians in here, I know you got parents like mine and you tell you to work hard. That is wrong. You have to work smart. You have a finite amount of time. First year, they're going to try to scare the bejesuses out of you. They're going to give you all kinds of hundreds of pages to read. They're going to say, work on your outline, work on your outline. You're going to work on your outline and you're going to get a low grade. If you're working hard, you're not working smart. What is an outline? This is not a history course. This is not writing a new encyclopedia. This is advocacy. So what I suggest that you do, the way you get good grades, is to get the examinations. Get as many examinations as you can. If you can get it from other law schools, get it also. Because there's a finite world, a very limited world of issues. The law professor can't invent new issues. The same law that's been taught for the last 300 or 400 years has the exact same issues. Once you know all of the issues, you take the exam of your professor or other professors and you outline them. Okay? For example, this was a contracts course. What's a contract? A contract is an agreement between two people to do something. Was there a contract? Was there a formation? Was there a meeting of the minds? Okay, was there adequate consideration? In torts, it's really simple. You have a cause of action. You have a prima facie case. You have an adequate defense. You have a counterclaim. Those are going to be the issues right there. Torts is really easy. It's all definitional. Okay? It should be 1, 2, 3. Now, since you know that, your job for the next 13 weeks is to pull out every damn exam from your professor that you can find. Now, in class, if you go to class, I didn't go to class that much. When you go to class, you listen with an open ear as to what the professor thinks is important. What the professor thinks is important is not necessarily what is really important in real life. Remember, the practice is much different from the study of law. If you don't practice, you do teach. If you don't teach, you do administer. Remember, I taught you that. So a lot of these professors have no real-world experience, but they're teaching from their perspective. So unfortunately, you have to accept it. Okay? So you have your exam. You review it once a month. You review it once for September, once for October, once for November, and you start writing exams. You start writing. You start using the outline, and you're going to find that your September version is different from your October version, different from your November version. Some professors are really lazy. The stuff that they teach in September, they have one problem. The stuff they teach in October, the second problem. The stuff they teach in November, the third problem. I've seen it before, okay? Some of them are actually, they try to integrate the stuff that happens during the semester. But again, there's only so many issues in every single subject that you're going to take in law school. And your job is to find the issues like the first week. All right? Once you find the issues, when you read through the materials and when you listen to the professor, it'll begin to make sense. But you've got to practice writing. Writing is the hardest thing to do because really you're facing yourself. It's sort of like, how many people here when they were kids, they took Chinese or Japanese calligraphy? You took Chinese calligraphy?
I took Japanese.
You took Japanese calligraphy? Okay. The first time the professor told you to write a character, boy, that looked pretty bad. The first month or two that you were in school, it looked pretty bad. But after like 6 or 7 months, you actually got the stroke, and it looked pretty good. Same thing writing exams. The first exam you write is going to be horrible, and it's going to be mush. You're not going to hit the target with a point, you're going to hit the target with a sponge. But after writing, like 4 or 5 drafts, it's going to be better. The gal who made law review, she wrote like 10 essays per course. She got out of Brooklyn, she goes to Northwestern Law School now, but she made law review. Okay, she really took what I had to offer to heart, she really practiced. If you want to get good grades, you got to start practicing writing. But before that, you got to identify the issues. Okay? Now I'm going to give you my email address. If you have questions, or if you want to give me a sample exam, and I am a very tough grader, don't take it personally. You can email me at the initial CC at chrischan.com, CHRISCHAN.com. If you can't reach me, or if it's copied down the wrong email, just ask Francis, because he knows me pretty well, and he can get in contact. Now, are there any questions about what happened during the first hour? Could you show me your exam so I can take a look and make sure everybody's circled words? Good? Not enough? That looks like Chinese. Good. That's good. 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 That's how the exam should look when you take your exam. Nice and messy. Very good. No, because it shows that you're thinking. And in the heat of the exam, when you read the question and you review, you will have all of the inferences and all of the key buzzwords in the margins that will help you write. It'll make it easier, and you're less likely to forget something. You want to be able to maximize your points, maximize your grade. The higher grade you get, the better chance you have of getting a job. Okay, do you want to do another torts, or do you want to do a crim law? It doesn't matter to me.
Crim law.
Crim law. Okay. Caplo? Okay. I was going to say, we got Bensley as well as McDowell. All right. It's Caplo it is. Question 1. We're going to start in the front. You, is it Star of Texas? Start, please.
Your boss,
Go.
that would be a potential party.
Why? This is criminal law.
I don't take criminal law. So
I don't care if you don't take criminal law. You're going to be tested in 3 years on the bar exam. You don't necessarily are going to take a course and be tested on it, so you have to think global. When you have boss, what does that implicate?
relation.
Right, very good. You in the black, keep going on.
We can't hear.
Boss shows a relationship. Possible, potential, liability. Keep going on.
After losing her wallet,
Whoa, that first sentence, is there anything else important?
received a call from one of his constituents.
Right, received a call. Why is that important?
Communication.
Communication shows, boy, didn't we use an N-word in the first session?
Notice.
Ah, notice, okay. Now, why is it important it's a call? This is criminal law. Correct, if it's not in writing, it's harder to prove. Evidentiary potential problem. And if it's a call, it's going to be a he said, she said situation. You in the red, go ahead.
Losing her wallet.
Go ahead. Why is losing important? Is it important? This is a crim law.
Yeah.
Got to switch gears. It's not important, is it?
I don't know, just
Continue on. Go ahead.
Someone had used her identity.
Holy shit. Go ahead. Edit that from the tape. Go ahead. It's identity theft. We know that. Go ahead.
Ordered 2 credit cards.
All right, what is a perpetrator? In Brooklyn, we call it a perp. But what's a perpetrator?
The person committing a criminal act.
That's correct. Okay. You in the gray, go ahead.
Ordered? Oh, no.
No. That's the correct word. Why is it significant? Because it shows in criminal law what's going to be important. There's certain crimes that require begins with an I.
Consent?
Correct. So if the person ordered, it demonstrates. Very good. You in the amen chair in the front. Go ahead. All right, that's the physical act. Keep going though. This is criminal law, so what's going to be important? M-O-N-E-Y. Now, why is that important? This ain't small potatoes. This is grand larceny. This is big buckaroos. Okay. Second row, gray t-shirt.
All over the state.
Why is that important?
Jurisdiction.
Say it another way. You got the right concept. It's all over the state. It's in one state. If it went over the state lines, it becomes a federal crime. But it's all within one state. Good thought. You got to work on your words. So you in the red. Go ahead.
Several people.
That whole sentence. What does it mean?
There was just more than one person.
Which means what?
More defendants, parties.
Correct. And it also allows the defense to point the finger of blame at somebody else. You in the cap, you're next.
One imposter actually caught,
Good. Keep going.
but could not be prosecuted.
Keep going.
Could not be prosecuted under federal law since he was arrested when trying to apply for parliament at a local election.
I know, why would a law professor put that in? They caught a perp. They caught a perp, but they can't charge him, right? They can't charge him under federal law. That doesn't mean they can't charge him under state law. There's no double jeopardy. You have two different entities, the federal government and the state government. I represented a guy, he was a former police officer from Stamford, Connecticut. He and his brothers went down to Atlantic City. One of his cousins worked in the U.S. mails, stole about 100 credit cards. These guys were idiots. They went down to the casinos, they punched them in, got into cash advance on all these credit cards. Don't they know that they got cameras in casinos? So they maxed out $2,000, $3,000 per card. Then they went over to the table and they promptly lost all the money. Everything's on tape. Okay? They got charged by the feds, prosecuted in Newark, New Jersey. We call it a white plastic case, credit card fraud. Then they got hit in Mays Landing on separate charges. And they said, isn't that double jeopardy? I said, no, it's double my fee. No. Basically, it's two different jurisdictions, and we had to, argue in both jurisdictions. As it was, I convinced the state judge that giving him concurrent sentence, meaning at the same time, would be sufficient. So all the guys took the federal time, and they liked it, because the state jails in New Jersey, it's not good. The feds are a lot better. Okay. That's in case any of you are thinking of a career change. In any event, okay. Read that whole sentence and tell me what's significant about that.
Me?
Yeah.
Again? One imposter actually caught, but he could not be prosecuted under existing federal law since he was arrested when trying to apply for a parliament at a local election.
Okay. Continue, please.
He was prosecuted for attempted grand larceny and forgery by the Brooklyn District Attorney for single transaction, the only incident for which there was any evidence, and was subject to 5 years in jail.
Okay, so he got charged in the locals at the Brooklyn DA's office, and it was attempted grand larceny and forgery. Okay. You're going to have an issue here of, is it a completed crime, or is it an attempt? All right? Obviously, the transaction didn't go through, so he's not going to be found guilty of the completed crime, but he's going to be found guilty of an attempt. An attempt is a lesser included in the actual crime. You might get lesser years for it. When you do criminal law like I do, you try to plea bargain out, try to make a deal with the prosecutor, and the charges are usually dropped at least one level. The time is also dropped accordingly. But oftentimes there's like an attempted sale of drugs, attempted possession. Legally, it's a fiction, and that's what we do a lot in the law. It's a fiction, but what it does, it gets your client a lesser sentence. Okay. For the single transaction, all right. He got 5 years. He was sentenced to 1 year in large part. I'm sorry, what am I doing reading? You in the black, it's your turn. Yeah, you.
He was prosecuted for attempted grand larceny and forgery.
Keep going.
He was sentenced to 1 year in part because the judge felt his nonviolent first offense was the only crime before the court.
Right, stop there. Okay, what's happening in that sentence? When you say he was subject to 5 years in jail, that's the max. Okay, but the judge gave him 1 year because why?
Because it was his nonviolent first offense.
Right, nonviolent first offense. Usually if you're violent, you got a weapon, it's a VFO, violent felony offender. We try to give you a little bit more time. They don't like people with guns, knives, other kinds of weapons. And since it's his first, we're going to give him a bite at the apple, try to let him choose a better life, shall we say. It's when you get repeat offenders, guys with rap sheets to the length of your arm, the judges are going to throw the book at them, because who wants a perp like that out on the street? He's going to commit more crime. But then again, you get career criminals. What is a career criminal? I represented a guy, a drug dealer down in Richmond, Virginia, last year. Okay, federal court, crack cocaine. He had 5 previous felony drug convictions. All right, this was the 6th one. On the 5 previous ones, he says, "Look, Chan, I pled out. I want to show." The evidence was overwhelming. If he pled out in the federal case in Richmond, Virginia, he's going to do 22 years. If we went to trial and lost, he's going to do 28 years. He was 34 years old. He spent more than half his life incarcerated. He says, Chan, give me a shot. I gave him a shot. We lost. You know? Sometimes you get paid to do a show. In fact, it was so bad, this was in the old Confederate White House in Richmond, Virginia. Jefferson Davis had an office in this building. Everybody talked with a southern drawl. There was one frickin' Chinese restaurant in the whole town. I knew I was in trouble. But the judge says to me, Judge Williams, after I finished my summation and the jury was let out, and the southern drawl, he says, Mr. Chan, I want to know what you ate for breakfast is your eggs, because your summation was a fly defense. Now, that's a federal judge. What are you supposed to do? I turned on my heel, I looked him straight in the eye and said, Judge, it's been an honor and a privilege to appear before you. Because you don't insult judges, and especially federal judges, because they will lock you up. It was quite a trial. I'll give you the details later. Who's up? You, number 73. Let's go.
Meanwhile, Ms. Druin had been hounded by creditors, denied a bank loan, and given a high-risk credit rating. She has spent hours and resources trying to clean up her credit problems.
So she's really screwed. Somebody stole her identity. Somebody charged $70,000 worth of goods, and now she's got all of these problems, okay? Victim impact statement, that's what's going on here, it sounds. Okay. You in the blue, you're up. No, not that one. This row, did we do this row? No, this row first. You.
Me?
Yeah, you.
Okay.
All right. Mrs. Drew's experience.
Ms. Drew's experience apparently is not common.
Right.
So,
Nothing important there. Go ahead.
indeed, there's a nationwide problem of identity theft. And
You missed a word. What's important there?
Nationwide.
Why? Because it presumed a federal problem. A federal problem. If it's a federal problem, it means there should be federal legislation. Crime doers in Alaska, Hawaii, Florida, New York should all be punished under a federal law. Okay. Next.
Problem of identity theft.
Okay. That's what we just talked about. Go ahead.
Just the definition of it?
Yeah, keep going.
Those strong views,
Right.
account numbers. Sometimes the victims are forced to declare bankruptcy.
Right. Well, basically, and which wrongdoers steal account numbers, identification documents, Social Security numbers. So there are all different ways that they can do it, which means what? That should be in the legislation, that if you steal a Social Security number, if you steal certain identification documents, if you steal credit card accounts or bank accounts, information, all of those would constitute that crime. That's how you do legislation. Okay. Mustard Shirt, you're up.
This conduct has been proliferating as more people have access to information online.
Oh, absolutely. Absolutely. Continue, please.
Current federal law, 18 U.S.C. section 1028, prohibits only the
The important word there is only. Anytime you see that in an exam circular, because you know it's going to be important. Keep going.
only the misuse of false identification documents.
Keep going.
Subsection A4 of the statute penalizes anyone who knowingly produces, transfers, or possesses identification documents other than one issued lawfully for the use of the processor, or a false identification document with the intent that such document be used to defraud the United States.
Now, do you understand that the stuff in the parentheses is very limited? It's limited because it's to be used to defraud the United States. What are some examples of where this statute would apply? What kind of documents would you present to the United States?
Passport.
Immigration stuff. Okay, I had a client out here in Brooklyn, Haitian guy, had his own store. When they finally went in on a search warrant, he had passports about 30 from different countries. He had Social Security cards that were numbered sequentially. He had 18 different notary stamps with different names on it. The guy was in business. But what made the case interesting is that his green cards, his Social Security cards, were real. He had diplomas from all kinds of universities, colleges, no law schools. But he had, other documents which were original documents. What made it interesting is where he got them. There was a corrupt consular office in Port-au-Prince, Haiti, that did business with him, and that's what made the case interesting. Because he was such an interesting fellow, I got him probation. But we won't talk about the details. Okay, so immigration is one. What other kind of things? Okay, taxes are going to be important, because you could use different names. I see your mind thinking. Don't think that way. It's not worth it. Continue in law school, please. Okay, next paragraph. You in the block.
A few bills have been proposed.
Right. Keep going.
Senator Mensa of Minnesota proposes an amendment to 18 U.S.C. subsection 1028A4 that would prohibit anyone from knowingly transferring or using without lawful authority a means of identification of another person with the intent to commit any unlawful activity that constitutes a violation of federal law or that constitutes a felony under any applicable state or local law.
Okay, Mensa's up to something. What's the distinction between the first and the second? The second one is broader. The second one includes state or local law, a violation of state or local law. So your net to catch criminals is much wider now. Before, it was just the United States, which limited to like cases involving immigration, taxes, other cases like that. Now, if it's a crime under local law, the federal prosecutors can go after them. That's significant. Okay, you who were thinking about crime, you're up. Yeah, you.
This other senator in Oregon believes the legislation should be limited to identity theft that results in actual financial loss. So then we have another version.
Okay, read that and tell me why that's different or has a distinction.
Having intentionally appropriated the identity of another in order to perpetrate a fraud obtains anything of value aggregating in excess of $10,000.
So there's got to be actual damages. So that wipes out attempts, doesn't it?
What's that?
It wipes out attempts, doesn't it? There has to be actual theft here. Also, it says intentionally as opposed to knowingly. So in criminal law, there's going to be different levels. There's going to be those crimes that have as a prima facie case intent. There's going to be other crimes that just knowingly. Of course, in the federal system, we have different standards. The standard in the federal system of evidence is one of pain, P-A-I-N. If it's painful to the defendant, that federal judge is going to get it in somehow. Okay, and that's how the federal system works. It's different from state. And this is the practice of the law. This is not what you study here at the law school. Okay. If somebody says they don't know something in the federal system, what happens? The prosecutor yells out, conscious avoidance. What is that? That means a person was in the position or should have been in the position or should have known that something else was going on. In other words, you just can't look away. That's how they get it in under the federal system, even though the person takes the stance that I had no idea what was going on. They'll use the doctrine of conscious avoidance to get around that. But that's what you learn when you get out of school. Okay.
Is that the same thing as willful blindness? Is that the same sort of concept?
Same sort of concept, but you get paid more if you use willful, I won't get it. All right, you in the striped shirt, go ahead.
Having recently attended a speech given by Justice Rehnquist, Senator status quo of South Dakota is convinced that we don't need any more federal laws. Larceny and forgery statutes are sufficient to address the situation when the harm is purely local. Leave the law alone. So we're basically saying that the laws shouldn't change, particularly when it's a local situation.
Right, and that's because Rehnquist believes what? Justice Rehnquist.
That they shouldn't add any more statutes?
Well, basically that the federal government should keep out of business that the locals can take care of. That's always been his policy. He's one of these people who believes in limiting federal laws and the federal interaction. If it's a state can handle it, let them handle it. Okay. Let's do the problem. Your senator asked you to think about and report back how Congress might address the ever-growing problem of identity theft by either writing a memo, either commenting on the various proposed statutes. What does that mean? That means you have to distinguish in your exam answer the difference between all three proposals, okay? Or commenting on the various proposals and describing your own version, holy smokes, of potential legislation that could address the problem. To answer this question, do not attempt to draft precise statutory language. Instead, articulate the intended goals of any proposed legislation, set forth the elements you would include in the statute, explain your choices. In addition, indicate how your recommended legislation would avoid any problem that might be raised by the holding in U.S. versus Lopez. Who read Lopez? Nobody read Lopez. Okay. Well, obviously, for this professor, when in the next several weeks he assigns you the case of Lopez, you got to read it more than once. Because obviously it's on the exam. It'll be on the exam. He's asked it before. He thinks it's important. Or the concept behind it's important. So I gave you just a big hint how to save a lot of time. Okay? Focus on Lopez, because obviously whatever's included in that is important. As for the legislation, he wants you to take a position in case you get a job working for a state legislature, or even a federal legislature, when you graduate from law school. And a lot of times they're thinking about, you know, what's the greatest good for the greatest number. Here we have a growing menace, a growing problem. Here we would have a federal law that would cover interstate commerce and even local commerce if it's a violation of the local law, which means what? We're shifting resources away from the state and local people to who? The federal people. Federal prosecutors now will be responsible for prosecuting this case. And the federals have a lot more money than local and state and city law enforcement people. You have better investigators. You have more training. You know, so that's what's going on here. We're shifting the resources from the locals to the feds. Okay. Plus, if you have on the internet a lot of interstate commerce, okay, it's better to prosecute in the feds because under the federal sentencing guidelines, the sentencing will be very similar. That's a more different kind of problem that I've seen in criminal law. Usually, they have a fact pattern and they say, what can he be charged for? You know? Oh, is this a federal one? Let me just see. Hold the phone. Federal criminal law. This is what you guys want to do, Caplo? That's what you guys want to do? Federal criminal law, or just like regular criminal law? Regular. Okay. Put this one down. Let's change gears here. I mean, I don't mind doing it, but I think you get more bang for your buck. Maddow? Okay. Ah, here we go. This is much better. Let's do MADOW. Did everybody have that exam? MADOW. Okay, where did we leave off? Maddow, MADOW, do you have that? If you don't have that, run up here and get one. I'll give you 30 seconds. 29, 28. I'm just teasing you, I got it. Maddow, M-A-D-O-W. This is more traditional. This is what you usually expect. Okay, where did we leave off? Who's up next? You? You're lucky. Go ahead. Convict. Next convict. What's important and why? Yeah, the next convict. What does that mean? Which means what? You keep talking like a layperson. If you're an ex-con, what does it mean? You have familiarity with the system. You're not a novice. You ain't a rookie. So if this problem involves interrogation, does it matter if you were told the Miranda rights? Hell no, because he ain't a rookie. He thinks of the system. Keep going.
What's eating up?
Kiala. That's like a bagel without a hole. Good with things you can. Yeah. All right, that's nothing bad. All right.
We walked outside with Conrad and
And
Conrad missed
Adverbs, come on. Why would a law professor put that in? Because it shows that these activities were innocent. You and your wife, go ahead.
Misread.
Right, which means what?
Mistake of fact.
You've been in a mistake of fact. This is an actual case, by the way. Keep going. Right. Misread the body language. Why? Because he's an ex-con. He was upstate in jail. And in jail, I've been to lots of jail. You got to be real careful when you interact with prisoners because they can make a mistake if you're going to make a move on. Okay. But he misread the body language. This is a real case. Okay. Go in the black with the Brooklyn on your chest.
Instead of frenzy of fear and rage, Hamlet whipped out his knife and stabbed Walter.
Right.
So knife, weapon.
Right. This is an actual case of having Gren killed. Okay. So the question then becomes, is it reasonable? Was it reasonable fear? It's different if you're in a prison ward, if you're in a prison cafeteria, and if you're outside. Butcher, go ahead.
Connor has been indicted for murder in the second degree near Carolina section.
Okay, that's a section for murder in second degree. They're different kinds. There's defied murder, extreme emotional. You gotta look up the statute. There's like 3 or 4 of them, or you just pop into your computer and take it off the web. You're his attorney, your defense attorney for this murder suspect. You're under Conrad as a Moser who developed like next. Okay. He tells you that based upon his prison experience, he felt certain that Walter was about to kill him. What happened right there? What's the defense? Does anybody know?
Conditioned response?
Almost. You're halfway there. The legal term is called justification. Justification is a legal term of art. What it means is that you have self-defense. I just won a case up in Westchester, and it was April or May. My client was charged with 2 counts of murder in the second degree, 1 count of manslaughter in the first degree, and 2 weapons counts to kill somebody. The facts were he was in a dice scheme up in Yonkers, New York. And CeeLo, 3 dice scheme, and won about $3,000. He picked up his earnings and was walking away. A friend of his, somebody that he knew, he grew up with, and spent time at his house, hit him on the side of the head. And when he turned, everybody went, oh shit. He had been cut. Cut from his cheek over his eye, half his ear was showing. You could see the jaw through his flesh. My guy pulled out a 9mm, shot at the top. 8 shots were fired, 5 hit the mark. They had a witness that claimed that my guy stood over the body, shooting down. One of the bullets was through and through, came out halfway in the front. He said, since the victim was facing down, the concrete stopped the bullet. I said, bullshit. He went to trial. And the forensic evidence showed that even though a bullet entered the center of the back, there was no burn marks. There was no gunpowder. When you shoot a bullet, out from the gun comes gunpowder following the bullet. If it was facing down, it'd be all over the victim's sweater. You know? He did infrared, no marks. He did a gray Walker test, no spots, which means it could not have been face down. It was at a distance of maybe 10 to 15 feet. The witness was lying. What caused the bullet to stop? Was there any microscopic concrete particles on the tip? It could have been anything. It could have been a medallion, it could have been a piece of jewelry. Jury did not really believe. District attorney argued excessive force to 8 shots. I said, fuck you. Well, I didn't say that. Jury, I said, there weren't 43 shots, and the victim's name is not Amadou. There's no excessive force. He said that my client had a duty to retreat. I know the jury. My client turned his back on this guy once, and he got cut like that. Do you think he's going to turn his back a second time? I don't think so. The jury believed him. Good. Since he used the gun, though, he's going to get the weapons count. That's all. Who's next? He felt certain that Walter was about to kill him. Is that reasonable? Is it reasonable for him because of the kind of person he is as an ex-con, or is it reasonable as an objective person in society? That's going to be the issue, though. Okay, who's next? I'm sorry. You in the striped shirt, are you next? You're next. You in the white shirt, go.
We're going to start reading.
He goes on to say,
It goes on to say I was like, it was like I was back in prison, something just snapped. The conditions we live in a world where certain explosive violence is a way of life.
keep going,
You can't show weakness and can't hesitate in the face of aggression.
keep going.
If you do, you're dead.
So this whole question revolves around the definition of justification and what is reasonable. What do you think his chances are? In this situation, not good, because it was an innocuous pointing of where the bathroom was. The killer's name was Jack. He recently died in jail. I think it was called the execution of song. This was not the case in New York. There was a fellow who was convicted of several heinous crimes, including murder. And there was a famous author who befriended him and got him out of jail, got him out on parole. And within several months after getting out of jail, this incident happened. He was sent back to 25 years to life. I think he recently died. This was actually a real happened.
Could you use the argument that, a client has to have the physical and the mental part, right?
Right.
Yeah, he didn't have the actual intent. It's like an involuntary movement that he
Did he intend the person to die?
Yeah. Oh, yeah, no. I'm saying that, yeah, he had no intent. His movement was just purely involuntary. It's like reaction as opposed to action.
I think there might be some disagreement.
No, yeah, sure. It does, I brought that up as a defense.
As a possible defense.
Right.
Okay.
And tried to support that.
I understand your theory. You're going to need a lot of extra testimony to get that to that argument. So you can able to trigger that argument. It's very creative. I'm not sure it's going to be very persuasive. You have to check with your expert. Yes.
Well, I mean, going along with what he was saying, like, could you go further and show medical testimony that the guy experienced trauma when he was in prison?
Oh, absolutely.
And that...
Absolutely. But the doctor's name is Roy Luber. He teaches or he works over at some business hospital. In fact, for my case, I wanted to call him to show that my client blanked out after the first or second shots. In other words, the excessive force. I was thinking of L'étranger by Albert Camus, if you ever read any French literature. The fellow was convicted in that story because he fired more than once and there was a pause. So that's what I was worried about. So I had hired an expert who had examined my guy twice and done an analysis. But I had taken the case over late for another attorney. If you're going to use psychological defense, you have to give notice to the DA. I give him 15 days of indictment, arraignment rather. And the other attorney did not. So I sucker punched the DA by saying, well, I want to have my shrink. And the DA screamed out. The judge blocked me, so I couldn't use it. And on the second exam, my shrink examined the client. He said he did have the intent to kill. So it's good that I didn't call him, but I lost. Okay? But we have a practice concern that sometimes you have to dance real fast. I'll teach you that when you go. Any other questions?
So then in questions like, I guess, criminal law, do you have to actually mention other cases that you've learned through the semester? Or do you even mention cases in exams?
You know, it's so tough. That's a very good question. It's tough because every criminal law professor is different. You got to know certain cases like Miranda, okay, Wong Sung Fu to the Poisonous Tree, Mapp versus Ohio, okay, Mapp versus Ohio is a search and seizure case that has the Fourth Amendment. In criminal law, it's really, practicing criminal law is so much simpler than practicing civil law. And judges in the criminal courts don't really write extensive memos as opposed to in the civil courts, because in the criminal courts you only have three really big things to think about. The Fourth Amendment, which is your right to privacy, right against unreasonable searches and seizures. The Fifth Amendment, which is the right against self-incrimination. And the Sixth Amendment is the right to counsel. Those really are the only three things that you have pre-trial to worry about. Were the defendant's rights violated? And as a defense attorney, you always try and trigger a hearing to determine whether or not those rights were violated. Cases get interesting if you have search warrants, or you have arrest warrants, or if you have wiretaps. Now, I've been practicing criminal law since '89. Before that, I did civil law, I did bankruptcy, I did immigration, but nothing captured my imagination like criminal law. I personally have over 15 A1 felonies just on suppression. A1 felony means it's more than 4 ounces of coke. Most of my clients have like kilos of coke. Okay, and I get them off. And they change your name and go back into business. I also beaten search warrant cases. I'm not trying to brag. I've beaten wiretap cases. The biggest case I won in the Fed was 101 kilos of cocaine. It can be done. Okay. But you like criminal law.